Thank you for joining the webinar. We will begin momentarily. And now may I present Vice Chair Jocelyn Samuels.
Thank you so much, and good afternoon, everyone. Welcome to today's dialogue with the U.S. Department of Labor, the National Labor Relations Board, or NLRB, and the U.S. Equal Employment Opportunity Commission, or EEOC. This virtual dialogue is entitled Ending Retaliation, Securing Racial and Economic Justice in the Workplace. I'm Jocelyn Samuels, the Vice Chair of the EEOC, and I'm privileged to serve as the moderator for today's discussion. This is the second in a series intended to raise awareness about and robustly address retaliation in America's workplaces. Retaliation, as most of you know, is often raised as a claim in cases that involve any number of other issues and can interfere with workers' ability to assert their rights under the laws that we enforce. Today, we will explore retaliation as it arises in cases involving racial and economic justice. We'll also talk about the ways that the enforcement authorities of our several agencies interact in these cases. That intersection is one of the reasons we're committed to conducting interagency training and coordination, as well as events like today's discussion, to ensure that we can most effectively protect the rights that the laws provide to workers. We are so fortunate to have a uniquely distinguished panel of speakers whom I'm pleased to introduce today very briefly. First, it's my honor to introduce Seema Nanda, who is the solicitor of the U.S. Department of Labor. Among many other accomplishments, Solicitor Nanda served in various leadership roles at the Department of Labor during the Obama administration, including Chief of Staff, Deputy Solicitor, and Senior Advisor to the Secretary. Our next distinguished panelist is Charlotte A. Burrows, who was designated by President Biden as chair of the EEOC on January 20th, 2021. Chair Burrows was initially nominated to serve as a commissioner in 2014 and was subsequently unanimously confirmed to a second term that ends in 2023. Chair Burrows seeks to enhance the EEOC's enforcement of all laws within its jurisdiction, focusing in particular on initiatives to combat harassment, foster pay equity, and advance diversity and inclusion. It's my pleasure to next introduce the General Counsel for the NLRB, Jennifer Abruzzo. General Counsel Abruzzo began serving in that role on July 22nd, 2021. She had previously worked for the NLRB for over 2 decades, including as Deputy Assistant General Counsel, Deputy General Counsel, and Acting General Counsel. Finally, I'm so pleased to introduce Jessica Lumen, the Acting Administrator of the Wage and Hour Division of the Department of Labor. Acting Administrator Lumen has served in that role since June 21st, 2021. She was appointed as the Principal Deputy Administrator on January 20th, 2021. So we'll now turn it over to our panelists for what I know will be an engaging and informative discussion. Solicitor Nanda, I'd like to start with you. Could you introduce us to your colleague and tell us things that you're seeing in the Office of the Solicitor?
Fantastic. Well, thank you so much, Jocelyn. And I am so delighted to join my colleagues from the NLRB, the EEOC, and the Wage and Hour Division to follow up on our launch of this initiative in November. And I'm particularly excited to be here today to hear from our regional representatives and get a little bit more nitty-gritty about what's happening on the ground. So when we last came together publicly in November, we marked the beginning of this joint initiative on anti-retaliation. And today, what we really want to do is share what that looks like a bit more on the ground and discuss how our partnership is really flourishing, especially as we work to protect our most vulnerable workers. So workers are our nation's eyes and ears for identifying workplace discrimination, inequities, violations, and hazards. And our message to workers today is this: Our agencies recognize that we are only effective when workers feel safe coming forward. And we are really committed to ensuring that you feel safe speaking up. And we are here to investigate and intervene if there is retaliation or the threat of retaliation when you do come forward. We know that the enforcement regime can be imperfect and that the costs of coming forward may take its toll. But please know that our federal agencies are intent on stopping retaliation as soon as we see it. So we are committed to a strategy of intervening early and often and working as one government to do it, whether that's conducting cross-training to understand each other's mission, referring cases to each other to better enforce anti-retaliation or other efforts, whether that's joint settlements when multiple agencies have related cases with different potential remedies, or whether that's providing technical assistance to each other. We recently provided technical assistance to the NLRB on calculating back pay in a workplace subject to prevailing wage, or whether that's doing joint outreach, because we know workers don't have an NLRB or an EEOC or a DOL or a wage and hour problem. They've just got a problem. So with that, I have the great pleasure of introducing Maya Fisher. Maya is the regional solicitor in our labor department based in Boston. So she covers mostly New England, and Maya and her team have really been at the forefront of our anti-retaliation work here in the solicitor's office, successfully bringing temporary restraining orders, preliminary injunctions to stop retaliation early, working very closely with our wage and hour division, as well as our OSHA colleagues on pre-litigation strategies and bringing robust skills and creativity as they do it. So with that, I'm honored to turn this over to Maya. Thank you.
Thank you, Seema. I'm so glad to be here to talk about our anti-retaliation work, which is so critical to what we do. As most of you know, the Department of Labor protects workers' rights on a number of fronts, including protecting workers from misclassification, wage theft, and unsafe working conditions. And as Seema mentioned, the successful enforcement of worker protection law depends on workers being empowered to and feeling safe enough to speak out for themselves and their fellow workers. And empowering workers to come forward about violations in the workplace is especially crucial when they face racial and economic injustice. For us, that means that when workers brave speaking up, we will use all legal tools we have to keep them safe. And we're seeing that employers are unfortunately becoming increasingly brazen in their threats against workers who seek to assert their rights, which requires us to act with urgency to stop retaliation. Although we have a variety of tools that we can use, one tactic we're increasingly using is to immediately go to court to seek preliminary injunctive relief in the form of temporary restraining orders and preliminary injunctions when we hear about retaliation. This means that if we're successful, there'll be a court order in place stopping an employer from retaliating without us first having to litigate an entire case. In the past year or so, we've successfully obtained this type of relief in 5 cases, and it's been under a variety of circumstances. We've intervened quickly and obtained orders when employers have threatened to call immigration authorities or law enforcement, threatened workers and their families by text, by letter, in person, threatened to fire workers and fired workers, or demanded kickbacks of wages, or blacklisted employees with potential future employers. So that's all critical to what we're doing. And as Seema mentioned, what we also see in our work is that workers are subject to different and intersecting kinds of workplace violations. In my office, we have 3 cases where we're protecting workers who are facing retaliation for concerns about both wage theft and unsafe workplaces. And similarly, we have 2 cases we're working closely with Wage and Hour on to potentially refer to the EEOC regarding allegations of discrimination. So that's just a bit about what we're seeing. Thank you.
Thank you so much, Solicitor Nanda and Regional Solicitor Fisher. Acting Administrator Lumen, I'll turn to you next. Could you introduce us to your colleague and help us understand these important issues from the perspective of the Wage and Hour Division?
Yes, thank you so much. And again, I want to share my enthusiasm with my colleagues here, having these conversations, talking to so many of you across the country about the importance of addressing retaliation. We think that this is so critical to our work. Outreach, education, and empowering workers is what we're here for and why we're here. And really, really happy to be having this conversation today. For those of you who aren't as familiar, the Wage and Hour Division enforces some of the most fundamental worker protection laws across the country, including minimum wage, overtime, child labor, family medical leave, and 148 million workers rely on us every day. And we have to be, as my colleague Solicitor Nanda says, we have to be a trusted resource for each one of those workers so that they know that they can exercise their rights and they can be safe in the workplace every single day. So addressing retaliation against employers, addressing the retaliation that occurs against employees who assert their rights to these worker protections is a priority of the Wage and Hour Division. And across the country, we are working to identify and prevent, and this is really critical. We have to prevent retaliation from occurring in the first place, because that's how we know that workers are able to access their rights and exercise their rights on a day-to-day basis. So we're working to prevent, and then when we do identify retaliation, to address and respond to harassment, threats against employees. And we use, as our colleagues will tell you, we use all of the enforcement tools available to us, from Boston to Connecticut to Louisiana to the West Coast. The Wage and Hour Division vigorously responds to the subtle and overt retaliation. Sometimes people think that retaliation is only when you get fired because you exercise your rights, but we know that retaliation occurs when there are threats against the employees and their families, when there's threats of deportation to workers, when there's instigation of bullying and intimidation by coworkers, and even, unfortunately, the use of firearms to intimidate workers to assert their rights. And while never acceptable, retaliation is particularly insidious for workers from marginalized communities. For example, the Wage and Hour Division recently helped Jose Sequeira, who was harassed and bullied by his Boston employer when he requested the overtime pay that he was legally due. Jose originally thought that he had been discriminated against on the basis of national origin, and he was right. But he also learned through working with us that he had also been a victim of wage theft and unlawful retaliation for raising his rights under the FLSA. So another example, Wage and Hour helped agricultural workers from Mexico who faced gunfire when they repeatedly asked for water in the heat of Louisiana summer. And these cases, unfortunately, are happening all over the country. And here to share our agency's response, we were thinking about this in an innovative and effective way, and how we can have as much impact as possible related to retaliation, is my colleague, Ruben Rosales, who's the Wage and Hour Regional Administrator in the Western region. For more than a decade, Ruben has led the West in pursuing these innovative means of protecting workers' rights and bringing the full range of tools available for the department to ensure compliance with our laws. Ruben is a leader in developing impactful enforcement strategies, and I'm really pleased to introduce you all to Ruben here today.
Well, thank you. Thank you for that. I appreciate it. It's a pleasure to be here and to share with you a little bit about what Wage and Hour does in terms of combating retaliation and trying to achieve social and economic justice for our workers. And one thing that I understand is my territory to the west, includes California, Arizona, Nevada, Oregon, Washington, Idaho, Alaska, Hawaii, Guam, American Samoa, and Saipan. So the territory is vast. So you can imagine the type of economic issues we have are vast in those areas. But let me just a little bit about our laws. It's built into our laws that we have retaliation protections, especially the Fair Labor Standards Act. It's a specific part of our law. And we try to help workers to understand that they can complain about their wages. They may ask an employer about their overtime, about their pay, or they may call us. Well, that's all protected activity. We need workers to understand that. In addition, we want people to know that we don't ask about immigration. Their immigration status is not something that we collect, nor their racial makeup is information that we collect in our investigations. Because we want to basically have them trust us. We don't want to create a chilling effect and have them not trust us and cooperate with us. It's very important that they do cooperate with us. It's important that we understand that, when we talk about economic and social and racial injustice, we're talking about people of color that are impacted in these different industries. And some of the industries that we focused on are industries where people of color and people are working, immigrants are working. For example, in agriculture in the West, it's predominantly Latino workers. In the garment industry, in the greater Los Angeles area, downtown Los Angeles, it's Latino workers. Orange County, it's Vietnamese workers. To the west of LA, it's Chinese and Thai workers. And then also in our facilities where we have hospitality workers and the casinos and stuff like that, it's a lot of Filipino workers. The care facilities, Black workers and Filipino workers. So you can see there's been some economic and social segregation in the workplace as well. And that's where we seem to focus our work in the low wage industries. So preventing retaliation is very important to us. And in order for us to be able to do that, we need the cooperation of the workers. It's very important that they understand that we're here for them. Because when we think about trying to combat economic injustice and racial injustice, and we think about the type of work that we do, it's not just about those kinds of issues. It goes deeper than that because we're trying to get people their money, back pay. And getting them their back pay, we're talking about a paycheck to cover their rent, a paycheck to buy clothes for their children, a paycheck to buy food for their families. So we're no longer talking about just labor rights, we're talking about human rights. So it's a pleasure to be here and to share with you some of our experiences as well.
Thank you so much for those educational and informative remarks, Acting Administrator Lumen, Regional Administrator Rosales. I'd like to turn next to the EEOC. Chair Burrows, could you introduce our regional attorney and talk to us about the EEOC's approach to retaliation and the ways it intersects with racial and economic justice struggles?
Absolutely. Thank you so much. And let me say first that the adverse economic impact of the COVID-19 pandemic has really exposed both the importance and the vulnerability of so many U.S. workers. And it's made clear that some of the most underserved populations, people of color, women, immigrants, and migrant workers, often end up doing the most dangerous work for the least pay. And throughout this pandemic, workers have continued to show up to jobs in food and agriculture, healthcare, and other essential work industries. But unfortunately, women and people of color tend to be concentrated in the very lowest paying of these jobs. And while applicants and employees in all industries experience retaliation, research shows that workers of color are more likely than others to be fired when they report the violations. And so the fear of economic harm leaves some workers feeling less willing to risk retaliation by challenging workplace violations. And many foreign-born workers fare even worse because they may lack authorization or they may have a temporary work authorization that's tied to a particular employer, which increases their vulnerability. So I'm really pleased to be able to introduce to you Mary Jo O'Neill, our regional attorney for the EEOC's Phoenix district, which includes Arizona, Utah, New Mexico, Colorado, and Wyoming. And I invited her to speak about her district's latest work in a long line of cases, challenging harassment and retaliation in industries like food processing, where people of color, women, and immigrants are especially vulnerable. And I'm pleased to share that her district recently obtained a $5.5 million settlement on behalf of close to 300 Somali Muslim workers at a meat processing plant in Colorado who had been harassed and retaliated against because of their race, religion, and national origin. So with that, Regional Attorney O'Neill, could you please tell us more about the case and what we can learn from it about the need to combat retaliation?
Oh, thank you so much, Chair Burrows. I'm very pleased to be here and to hear from all of my colleagues from around the country and other federal agencies. As many of you know, the EEOC prioritizes the protection of migrant, immigrant, and vulnerable workers from discrimination, harassment, and retaliation. This is a priority in our strategic enforcement plan, and it's something that we all think is very important, and it is important work that we all do. What's important for workers to know is a couple of things. One is just to know their rights. And so we're all doing outreach here today, other times, telling people what their rights are, telling workers what their rights are. And for us, just like Ruben said earlier, is we don't care about people's immigration status. So people are protected under EEOC's laws, regardless of their work authorization status, regardless of their immigration status, regardless of their citizenship. It just doesn't matter to us at all. But it's not necessarily easy to reach out to these vulnerable workers, the most vulnerable workers. You know, there's all sorts of barriers to that. Folks are afraid to speak out because of their work status. There may be language barriers. There's often language barriers. Often they're in isolated communities, rural communities where there's little support. They're isolated often in their workplaces. They're in fields, they're in warehouses, they are out in meat processing plants. And we encountered all of these challenges in the JBS Swift case that the chair talked about. I'll tell you a little bit about that case because I think it's instructive. In this case, hundreds of Black Somali Muslims were working at this meat processing plant in Greeley, Colorado. And they were harassed in really offensive, egregious ways because of three things: because of their race, because of their national origin, and because of their religion. They were disciplined and they were terminated if they spoke up and objected to the abuse that they were receiving. And they also were retaliated against because they asked for religious accommodation. At the time they started working at this plant, they were very recent refugees. Most of them had very limited English proficiency skills, and many of them were illiterate. And they didn't know about what our laws protected, what kind of protections our laws had for them. And they did hard work, dangerous, difficult, hard work. They worked as butchers, they worked on the shipping, they worked doing boxing, there were fast production lines, there was heavy lifting, there were knives, it was cold, it was dangerous, it was tough, difficult work. And they worked in this area for between $11 and $13 an hour. And this job was one of the few jobs they could get in the rural area of Greeley, Colorado. And when they worked there, unfortunately, they were subjected to egregious harassment. There was terrible graffiti in the bathrooms that was anti-Muslim, that was anti-Somali, that was racist slurs against them because of their race. They also had coworkers and managers who called them vulgar names. And they also had meat thrown at them while they were working, bones, blood, fat of meat thrown at them while they were working. And they were also deprived of the ability to do their prayers as required by their religion. I'll tell you about one particular man that's, I think his case is illustrative, is Hassan Abdi Farah. He was in his 70s when he was working at JBS Swift. And his supervisor kept on giving him harder and harder tasks, more difficult, progressively more difficult. And he was also having bones and fat and blood thrown at him while he was working by his coworkers. So of course, he went to his supervisor and said, this abuse has to stop. Please stop them from doing this. And the supervisor said to him very explicitly, don't you complain or you can lose your job. So this is the kind of chilling retaliation, very overt. And despite how terrible these folks were being treated, when we started our case, people were very reluctant to participate at the beginning. It's the trust building that was talked about earlier by prior speakers, which is they were afraid that they were going to be fired because people had been fired for speaking up. And they were also afraid that this company was going to affect their ability to get their citizenship. Yeah, big fear for them. So I think this case really illustrates what we've been talking about, which is the intersection between different kinds of discrimination. It's race, it's ethnicity, it's economic status, it's immigration status. And all those things intersect to affect people's lives and their livelihoods. So I think it's very important that we use all of our available resources to reach out to these communities, to educate people about their rights. And also, it's really important to bring these cases. I'm so happy to hear about the cases that our colleagues are bringing around the country to protect workers. Thank you so much.
Well, thank you so much, Chair Burrows and Regional Attorney O'Neill, for these sobering and really informative remarks. I'll move now to the NLRB. General Counsel Abruzzo, please introduce your colleague and share with us NLRB's big picture perspective on these issues.
Thanks so much, Jocelyn, and it's so good to be here and to be with all of you today. I will just start by saying I am heartened to see a movement in this country in the broad sense, to see that workers are not exploited, but rather that they get the pay and protections and equal opportunities that they deserve. And we, this group, recognize that we need to actively be a part of that movement. That's why our partnership and this anti-retaliation initiative is so critical. We are striving for the strongest collaboration and networked enforcement possible in order to protect workers who raise their collective voices, to combat all forms of mistreatment, and to hold accountable those who try to silence them or quash their efforts to improve their circumstances at the workplace. As many of you may know, the National Labor Relations Act protects the rights of workers to band together to improve their working conditions. And because our statute broadly covers many employees' collective actions undertaken to address a myriad of workplace concerns, those activities often intersect with those implicating other worker protection statutes, including, for example, Title VII, when we're dealing with group complaints about racial discrimination, also the Fair Labor Standards Act, when we're dealing with group complaints about wage theft of vulnerable populations, as was just discussed, including immigrants and people of color. So it is with my great pleasure that I introduce my colleague, Lisa Henderson, who, after a very long career in various positions of increased responsibility at the National Labor Relations Board, was appointed regional director last year to lead our Region 10, which covers 8 southern states. The hub is in Atlanta, and then we have satellite offices in Nashville and Birmingham and Winston-Salem. And she's going to discuss her experiences on the ground in protecting crucial workers' rights. So I turn it over to Lisa.
Thank you. Thank you, Jennifer. And it's a pleasure to be here and a pleasure to be able to tell you a little bit about what we do at the NLRB. The region in which I work spans the area from just below Richmond, Virginia to just above Montgomery, Alabama, basically the 2 capitals of the Confederacy. And the past here is not very far past. For example, I'm not very old, but I was born in a segregated hospital in North Carolina. So these issues, historical power imbalances, barriers to access, exclusionary networks, these are still very much in play in the region in which we work. The NLRB has a very specific mandate, but our unfair labor practices don't arise in a vacuum. And we can't just extract our piece like a knee bone in the old board game Operation from the larger context of employees' work environments. For example, one of the most impactful cases of my career involved the discharges of 4 African-American women from an Atlanta hotel in retaliation for their protected concerted complaints about their working conditions. They were under increasing pressure to clean their hotel rooms more quickly. When their complaints to their supervisor went nowhere, one approached a hotel manager to ask for help on behalf of herself and other workers, which is the crux of protected concerted activity. Within a matter of days, the 4 ringleaders had been fired for an assortment of trumped up violations. One woman, who was diabetic, regularly took a morning break to check her blood sugar levels. She was fired for stealing time. Another woman found a bathrobe in the employee locker room, recognized it as a guest bathrobe. She was rushing to see a sick relative. She stashed the bathrobe in her locker to turn it in the next day. She was fired as she exited the building and charged with stealing. So we went to trial, and after trial, I explained to the workers what would happen next. And one turned to me and said, "You know what? I don't even care. For the first time, we got the chance to speak, to be heard. And these people had to sit there and listen to us. And that for me was a really powerful affirmation of what we do at the NLRB and why we do it, to be able to protect the most vulnerable workers, women of color, so-called unskilled labor, working low wages for long hours in economically segregated jobs in which people don't see them, only what they have or haven't done. To be able to gain redress for these workers from the harsh consequences of even their most basic attempts to assert their rights is at the heart of the National Labor Relations Act. But as satisfied as this worker was, I knew that the NLRB's remedies have limits. And I wonder what further relief these women may have gained had we had the kind of partnerships with other federal agencies that we're now building. So often, when you have low-wage workers, who are very often people of color, speaking up in a workplace like the hotel I discussed, there are also wage and hour issues, there are health and safety issues, there are issues of race or sex discrimination. If we can harness the force of interagency coordination, I have no doubt that it will make an enormous difference in the lives of workers everywhere. Thank you.
Well, thank you so much, General Counsel Abruzzo and Regional Director Henderson. That's an excellent segue to the next segment of our presentation, where we will ask each of you to respond to questions, some of which came from members of our audience today. And as you alluded to, Regional Director Henderson, retaliation seems to be a particularly sticky issue when it implicates the enforcement authority of multiple agencies. So many in our audience want to know a little more about the NLRB and Wage and Hour Division Memorandum of Understanding and how it will help workers facing retaliation. I'll start with you, General Counsel Abruzzo, and then ask you to turn it over to Acting Administrator Lumen. And so that we can get through the maximum number of questions, let's all try to be streamlined in the way that we address these issues. Thanks so much.
Either that or talk real quickly. So the purpose of the MOU that the NLRB has with the Wage and Hour Division is, in essence, to improve our respective enforcement efforts by having a greater understanding of what's actually happening on the ground with workers in any particular circumstance. So again, we can hold those accountable who violate the rights of workers we protect, and so we can provide full relief to victims of such violations. And unfortunately, way too often, as we've heard, we see that when one worker protection statute has been violated, so has another. So through better collaboration and coordination and resource sharing, we think we can be even more productive. And so first of all, we're committed to training each other about specific statutes and experiences in order to help each other identify issues under the other's jurisdiction. And if during an investigation, one agency believes there may be unlawful conduct that falls within the jurisdiction of the other, they'll advise the worker about potentially filing a charge or complaint with the other agency, and we'll provide informational materials about statutory rights and remedies and contact information for that agency. Secondly, in certain cases, we'll decide whether it makes sense to conduct coordinated investigations when matters arise involving overlapping statutory violations. This could include whether it's appropriate for one agency to take the lead in investigating, settling, or litigating the case while the other holds their case in abeyance, or it could be whether it makes sense to conduct a joint investigation, perhaps resulting in a joint settlement or joint litigation of violations found. We do think that it's anticipated that that would reduce resource expenditures for all our agencies, as well as for the parties. And workers in particular in getting remedial relief more quickly. And we plan to share information from our investigative and complaint files relating to alleged violations of our respective laws, such as unlawful compensation practices, discriminatory hiring practices, or other unlawful employment practices, including retaliatory discipline or discharge, or exploiting employees' work authorizations or immigration status. And we relatedly plan to share information about purported violators of our laws involving those involved in complex or fissured employment structures, including single or joint employers or alter egos, as well as those that have business models designed to evade legal accountability. And then finally, I'll just say, as we all know, and we're trying to do that here today, we want to engage in more fully in joint public education efforts. And that includes conducting outreach events, updating our worker.gov website, our employer.gov website, and other resources, and drafting documents to facilitate a greater understanding and awareness of our laws and the intersection between the two. So I'll turn it over to Jessica.
Thank you, General Counsel Bruzzo. Again, I would just want to echo everything you said. And I also want to just echo, one of the things that we're hearing a lot about today is that workers don't lead single issue lives, that, they come to work every day and they bring with them everything that they are and everything that they need. And it shouldn't be up to them to try to have to navigate their government. Their government needs to be here to really help serve every single one of those workers. So I think one of the great things about this collaboration between the Wage and Hour Division and NLRB is that we can help navigate which statutes need to be enforced. We can help identify the violations that workers may have been subjected to, so that workers do not have to do that on their own. And so again, cross-training, referrals, outreach education, all of these things will help the Wage and Hour Division, which focuses on low-wage vulnerable workers that are most likely to have violations related to misclassification as independent contractors or, unfortunately, retaliation. Will be able to help prevent, deter, detect, and then address all those violations. I think the only other thing I would say is that this type of collaboration doesn't just help those workers, though. It doesn't just help the workers that are involved in a case. We also help this kind of hope this collaboration will promote the types of workplaces and the worker protections and empower workers across the country. Because as we know, a worker getting their rights observed in the first place, a worker getting their pay on payday makes the difference. And while we're here to enforce the law, we really want workers to get everything that they should be getting every single day in every single workplace. And this type of collaboration can help us do that.
Thank you so much to both of you for that tremendous illustration of interagency collaboration. And today's event, I think, is another example of the ways that all of our agencies are committed to working together to protect the rights of workers. I'll turn to Regional Attorney O'Neill at the EEOC. Can you tell us a little about what else federal agencies can do to inform workers of their rights and protect them from retaliation?
Oh, absolutely. As you know, those of us out in the field have relationships with our sister agencies in the field. We also have relationships with nonprofits. We have relationships with community groups. We have relationships with workers groups. And it is important that we keep those relationships and really build on those relationships, which is illustrated by today's activity, I think. I concur with what was said before. We need to make sure that we educate our own staff so that we can make appropriate referrals. We need to coordinate when appropriate, which it's often appropriate. I'll tell you about a case that we recently did in, it was in Steamboat Springs, Colorado. And that was, it's a restaurant, and they hired mostly undocumented workers from Mexico and other parts of Latin America. And these workers were subjected to terrible national origin harassment. They were called names, et cetera, and they were also denied overtime of pay. They were also paid very irregularly, like every 7 or 8 weeks. The employer took illegal deductions. And so this fact pattern, of course, implicates a couple of our agencies and a couple of our laws that we're talking about today. We normally think of a wage theft case like this as strictly a wage and hour case. And of course, it is a wage and hour case, part of those facts. But it also implicates Title VII, because these workers were not given their wages because of their national origin. And we want workers to know, if you're not getting paid properly, if you're being underpaid, if you're not getting your pay regularly, or if your employer's treating you differently because of your national origin and also harassing you because of your national origin, that's also a Title VII violation, and the EEOC is very interested in that. We have, in terms of working together, I know that yesterday our wonderful Chicago office had a joint seminar with the Minneapolis Wage and Hour office, and they did a joint seminar for employers and for workers to tell them about their various statutes and how to file complaints with the 2 different agencies. And I think this is just the beginning of many such collaborations. You're going to see more and more of this kind of collaboration. One thing I want to mention in terms of reaching out to the kind of communities we're talking about is that we really need to meet people where they are. And this includes speaking the languages that they speak, also using the social media that they use to share information. One of the things I learned working on the JBS Swift case is that the Somali community has a Somali YouTube website, and that's how they get their news. So that was a way that we could communicate with the community. I think those are the kinds of things that we can do. Thank you.
Thank you so much, Regional Attorney O'Neill. Let me turn it over to Regional Solicitor Fisher and Solicitor Nanda. Can you talk a little bit about how retaliation specifically impacts immigrant workers?
Absolutely. First, our worker protection laws apply to workers regardless of status. And retaliation with respect to actual or perceived immigration status is absolutely acceptable, but all too common. We've seen employers threaten to report workers to immigration authorities for bringing claims or cooperating with investigations. It's egregious, and we do not tolerate it. It's for that reason that we work closely with DOL enforcement agencies to intervene immediately when we learn of this type of retaliation, because we know how harmful it can be for immigrant workers. It's also our standard practice to seek injunctive relief from courts, preventing employers from threatening employees with immigration-related consequences for asserting their workplace rights.
Solicitor Nanda?
Yeah, thanks, Maya. One thing I wanted to pick up on Maya's remarks and build on is to discuss our work a little bit with the Department of Homeland Security. So a worker's lack of immigration status and vulnerability to retaliation and deportation can, as everyone has talked about, really thwart enforcement efforts and leave workers extremely vulnerable to abuse. So supporting workers' requests for certain temporary immigration relief based on their involvement in a labor dispute is one way that DOL can help insulate worker witnesses from employer retaliation and provide an incentive for workers to speak to DOL investigators and attorneys. And I can tell you, in addition to everyone here on this panel, our DOL Secretary Marty Walsh, DHS Secretary Mayorkas, both have a strong commitment to this work. And by this work, I mean ensuring that DHS's efforts to enforce immigration laws do not thwart workers' ability to enforce their workplace rights. So along these lines, we have a long-standing MOU with DHS that we work to strengthen in the Obama administration and that we are working to strengthen again now. In 2016, there was a substantial revision to that MOU between DOL and DHS, where the EEOC and the NLRB were added to that agreement, which has been hugely impactful. The MOU's purpose is to ensure that DOL and DHS's respective worksite enforcement activities do not conflict with each other. One important tool is it compels ICE to essentially stand down during the pendency of an enforcement effort by a labor agency in most cases. And in the spirit of that MOU, DHS agrees to consider requests that DHS grant a temporary parole or deferred action to support worker witnesses. So that MOU represents a really important tool for us to utilize to make sure that we're protecting immigrant workers.
Thanks so much to both of you. Regional Administrator Rosales, do you have an example to share?
Yeah, I'll quickly, so I know when time is a couple cases that I'll mention. One case, a construction case that we had out of Arizona, the workers were threatened with their immigration status and told not to cooperate with us. In that particular case, working close with our solicitor's office, we were able to get a preliminary injunction against the employer and their lawyer to get them to stop and basically return some workers back to the workforce. They had to rescind some of the terminations. They threatened them with lowering their pay. So that's one example. Working close with our solicitors, we're able to combat retaliation. Another case that we had in the far island of Saipan, we had workers using the H-2B program. Those workers, we had workers from Taiwan, workers from Italy, workers from Mongolia, and workers from Turkey. And so, and those workers there, we basically saw the pay difference. Initially, no one got paid. We got involved. They ended up paying the Taiwanese workers and the Italian workers first and paid them actually above the rate that was supposed to be paid. And they didn't pay the Mongolian or the Turkey workers, and they left them below the rate. And we had to step in and do that. So basically, due to national origin, we had people that were treated differently and not paid correctly. In that Saipan case, we're still in litigation, but we have a finding of over $3 million in that case. And finally, what's disheartening for me as a Latino in the community, not only involved in wage and hour work, but in the community, is to see that our immigrant population is impacted by their own people. And for example, what we see is in the farm workers, we have the farm labor contractors are predominantly Latino, and they're predominantly the ones that are taking advantage of their own community. And so with that, that's why these forums are important. And I hope that we can take these opportunities to teach the employer community as well as the employees what their rights are, and that wage theft is an issue and retaliation is an issue.
Wonderful. Thank you so much for sharing. Regional Director Henderson, do you have a quick example that you'd like to share?
Yes, and this example also shows sort of the intersection with these issues with different agencies. And this involved a case with two Jamaican nationals who were working at a resort on H-2B visas for 6 months. They got there, they had been assigned to apartments that were really far away from the resort, no transportation. They complained. They complained both to the employer and to the Jamaican Employment Agency, and they got nowhere. One person happened to hear about a meeting with the Southern Poverty Law Center. These employees went. The employer heard about it, called them in, fired them, and gave them a ticket to go back to Jamaica in 2 days. So not only were these women losing their jobs, guaranteed jobs, they were being evicted from an apartment. They had bought items that they had planned to ship home. They didn't have time to ship them. They got in contact with Southern Poverty Law Center, who contacted us, filed a charge, but under the terms of their H-2B visa, they had once you're fired, you have 10 days to leave the country. So there's this mad scramble that erupts with us trying to track these women down, trying to get evidence, trying to get affidavits. I mean, there's often a heightened sense of urgency in immigration cases, but this was exponentiated. So for these types of cases, last fall, General Counsel Abruzzo issued General Counsel Memo 2201. It's a public memorandum, which lays out the policies and procedures, the agency's policies and procedures for effectively serving the particularized needs of immigrant communities and ensuring that the NLRB is not only accessible to all workers, but is also a safe place where people are treated with dignity without regard for immigration or work authorization status. And these procedures include working with DHS, as mentioned earlier, via either ICE or perhaps USCIS for quick immigration relief, such as deferred action, stays of removal, U or T status for non-citizens who are victims of or witnesses to unfair labor practices. Thank you.
Thank you so much. I'd like to turn to Chair Burrows just to ask about what you've seen about the impact of retaliation, particularly on workers of color.
Yes, well, thank you for that. And it has been really at the center of our work at the EEOC for a very long time. We are the agency that was created in direct response to the 1963 March on Washington for Jobs and Freedom. And the issues of entrenched racial discrimination that give rise to that really gave rise to our agency, unfortunately, are still having an impact today. So these joint efforts really could not be timelier. In May 2020, we saw the brutal murder of George Floyd, and so many other persons of color really bring to the forefront those long-standing issues of racial and economic inequality. And the COVID-19 pandemic has also exposed some really deeply ingrained inequalities and economic issues So we have been working on those. This context, as I said earlier, has, with the pandemic falling so heavily on persons of color, has meant that the pandemic has become not just a public health crisis and an economic crisis, but really a civil rights crisis. And yet at the same time, we see diverse coalitions across this country calling and working and marching for racial and economic justice, and some employers seeking to broaden the diversity of their workforces and attract some historically underrepresented workers in that context. So that's the big context in which we are looking at this work now at the EEOC. And there's really a growing consensus across the country that it's finally time to make real and lasting change. And that's what we intend to do. But we know that to do that, we have to focus directly on retaliation, because fear of retaliation is so often what stops workers coming forward to report discrimination. And I'll share with you one example from one of our cases that can help explain this broader picture. It's also a case from Phoenix, so congratulations to Regional Attorney O'Neill on that. We were able to obtain $20.5 million for about 21 female and Black employees of Jackson National Life Insurance. And because of their race and because they opposed discrimination and harassment, the employer had retaliated against them, subjected the charging parties to a hostile work environment, and shortchanged them on compensation and regularly passed them over for promotion. And the company also fired a white vice president who refused to give a negative evaluation and a disciplinary warning to 2 African-American women who complained. And so this pattern of really long-standing discrimination and retaliation denied these workers coming together. The retaliation kept that discrimination in place and denied these workers the lucrative assignments and advancement opportunities in an industry, frankly, that has a significant history of subjecting workers of color to racial discrimination. And according to our most recent data here at the EEOC, we, in the private sector at least, Black, Hispanic, and Native American workers are nearly 5 times as likely to be underrepresented in senior management at finance and insurance employers, which is where this employer was situated. And women are only about 31% of senior executives within this category nationwide. And Black, Hispanic, Asian, Native American, and Pacific Islander women make up less than 5% of finance industry executives. So this lack of representation can also leave women and workers feeling isolated and reluctant to come forward to report harassment or discrimination when it occurs, even if you have a different kind of an employer. And it can get in the way of an employer's efforts to create fair and inclusive work environments where workers feel safe to assert their rights without fear of retaliation. So not only is this something we have to focus on in workplaces that have really entrenched problems, but it's also important to know that preventing retaliation really has to go hand in hand with efforts to address equal opportunity in any employment situation, and particularly for persons of color.
Thank you so much, Chair Burrows. And I will give the last word to General Counsel Abruzzo. Can you talk a little bit about the work that you're doing to protect the rights of workers of color from retaliation?
Or, sorry, I just had to turn on my video again. Yeah, I mean, Section 7 of our statute protects the right of workers to initiate, induce, or prepare for group action for the purpose of mutual aid or protection. And I believe that racial and economic justice advocacy, where the subject matter has a direct link to workers' interests in being treated equitably in the workplace, is protected. So if workers act together to address racial inequity or bias or discrimination broadly and specifically in their workplaces, and their employer unlawfully interferes with that activity by banning it or retaliating against it by firing them, for example, we're going to prosecute. And we've issued a number of complaints since I've been general counsel, and we're currently litigating cases where we're seeking remedies for interfering with workers' racial and economic justice advocacy. In Region 18, which is in Minneapolis, we're litigating a case against Home Depot that we feel they discriminated against an employee for raising issues of racial harassment with coworkers and managers and displaying a Black Lives Matter slogan on his apron. And in Region 20 out of California in San Francisco, we're similarly litigating a case alleging that Whole Foods violated the act by enforcing a rule that prohibited employees from wearing face masks and other apparel that had Black Lives Matter messaging on it. So my message to workers in this country is, if you exercise your right to band together to improve your working conditions and you're unlawfully retaliated for doing so, we are all here to help you, to educate you, and to remedy violations of your rights. And I hope that this webinar empowers you as workers to elevate your voices and to engage with one another and work with us towards eliminating all discrimination, inequity, and mistreatment in your respective workplaces.
Thank you so much, General Counsel Abruzzo, and you spoke so quickly that I think we have time for a really quick lightning round of closing thoughts. 30 seconds for each agency. I'll start with the solicitor's office.
Thank you. I just want to say in closing that workers should feel like the department is there. We are ready for you to come forward throughout everywhere in the country. We are ready to intervene early and bring these cases and even consider them when there's just the threat of retaliation or reason to feel like there would be a threat. And we really look forward to working with our interagency partners on this initiative. Thanks so much.
Wage an hour.
Thank you. I just want to echo everything that's been said today and just recognize that combating retaliation is a racial and economic justice issue. And that's how we look at it, and that's how we work together. And we are here to help anyone who has concerns, issues around this. I'm going to give you my 1-800-818-66-4-US-WAGE. Call us. We want to be available to you. And thank you so much for joining us today, and also for really your commitment to addressing this issue. So thank you.
EEOC.
Absolutely. Well, I have to just echo that we want to hear from you if you're experiencing problems of retaliation based on race, national origin, gender, including pregnancy, sexual orientation, gender identity, as well as disability and age and religion. And this is the time, I think, where we have the national will to live our values with respect to anti-discrimination, and we have to get in front of it. As our nation recovers from a pandemic that's disproportionately affected vulnerable workers and workers of color, our agencies joining together now can really make a difference if people do come forward, and we're committed to doing that.
Well, thank you all so very much. This has been an extraordinarily rich and important dialogue. Thank you to all of you in the audience for joining us. I know that I can speak on behalf of my agency colleagues in saying, we want to hear from you. We are here to help advance the laws and protect your rights. I think we'll have a slide at the closing that will give contact information for each of our agencies. Please stay tuned for more information about the work that we will all be doing together to advance the values that we all share. Thank you to our panelists. Thank you to our audience. Thank you to our interpreters. Thank you to the tech people who made this happen. We're all committed to winning these battles together. So thank you all. We'll look forward to the next occasion to talk.